Now that we've done a quick overview of the three mental states, I want to focus on the examination of the mens rea of intent in the context of a specific crime that requires this mens rea. So let's turn to State v. Stewart. Here, defendants were charged and convicted of attempted robbery. There were 3 of them, and they were bound together by what we're going to call a conspiracy. All 3 of them were charged and convicted of this crime. This was a bench trial. Did you catch that phrase in the opinion? A bench trial means that the trier of fact was not the jury, but instead the judge. That's quite unusual to have the judge be the trier of fact. Usually we want a jury and not a judge to make the decision. But sometimes, where it is a complex set of facts or a difficult legal principle, sometimes we prefer that it go to a judge to both decide the law and the facts of the case, and that's what happened here. For attempted robbery, we have to prove the mens rea of the intent to commit the crime. So when looking at that mens rea, the mens rea would have to be the intent to rob a victim. That mens rea is going to look as follows. We're going to have to show that they intended to take the property by force or threat of force, and that they had the intent to permanently deprive. The second element the state has to prove is the actus reus for attempted robbery. Here the prosecution has to prove not only the intent, but that there were sufficient acts that our defendants committed in furtherance of that criminal intent. How close did they get to actually committing the robbery? That's what we're looking for in the crime of attempted robbery. Before we get into that, though, I want to talk about what happened here procedurally. So our case is up on appeal to the Wisconsin Supreme Court, but let's look at the beginning. First, defendant was convicted at the trial court of attempted robbery. We know defendant had to be convicted at the trial court level for there to even be an appellate opinion, because if our defendant had been acquitted, double jeopardy would have attached, and that would have been the end of the story. But our defendant was convicted at trial. Now there's an appeal because he waived his rights to double jeopardy in order to create that appeal, to say I shouldn't have been convicted of attempted robbery. The moment defendant appeals the verdict, double jeopardy no longer applies. When defendant appeals, it went to the Court of Appeals, who listened to defendant's arguments and said, you know what, we think you're right. And the Court of Appeals reversed the conviction based on a reason in the contempt law that we're not going to discuss here. So at this point, defendants won at the Court of Appeals level. Because there is no double jeopardy principle that's attached, the prosecution can appeal this Court of Appeals ruling. The principle of double jeopardy doesn't prevent this. That's how it gets to the Supreme Court of Wisconsin, who then decides to reverse the Court of Appeals ruling and reaffirm the trial court's opinion. So we're examining Stewart here. But with every case you read in criminal law, indeed every case you read in law school, I want you to always ask yourself, why am I reading this case? Why has the case book or the professor given me this case to read in light of the theme we're discussing? What's the main theme? What's the main rule I want to pull out of the case that contributes to my understanding of the law? Here we're reading State v. Stewart to help us understand how to prove the mens rea of specific intent. So the question we need to consider here is, do the facts support a belief that our defendant intended to rob the victim? Can we say when you look at those facts that that's what the defendants intended to do? Did they intend to take by force or threat of force and permanently deprive the property from the victim? So let's look at the actions. We've got 3 men approaching the victim who's standing inside a 3-sided plexiglass bus shelter. 2 defendants went inside, 1 stood immediately outside, almost blocking the entrance. To the prosecutor shaping the narrative, telling the story, it feels like they were cornering him. Now look at what the defendants said and did. Want to buy some cigarettes? Was their first question. Then they said, give us some change. Then they repeated that question, repeated that statement, give us some change, louder voice, increasingly loud, increasingly aggressive. Now it's all about the context. Were they trying to rob him, as the prosecution's arguing, or were they just panhandling or begging, as our defendant is claiming? If they're trying to rob him, they've met the specific intent. If they're just begging or panhandling, then there's no criminal mens rea and they should be acquitted. But now I want to add more facts. Now we're going to add that one defendant reached into his coat pocket as though to pull out a gun. and the other defendant said, "Put the gun away." Remember, this is a conspiracy, so the acts of one are attributed to the acts of the other. The fact that one defendant showed the gun helps to also support the intent to rob. The fact that the guys walked away and came back later, the prosecution says, doesn't change anything. They still wanted to rob our victim. They still had the intent to rob the victim. What do we want to do about the victim's state of mind? Here the victim says he was scared throughout the entire encounter, which lasted, I think, about 3 minutes. He was frightened, didn't go to the police, but he was very frightened. Because this is a crime of specific intent, it's important for us to know what the victim thought, but it does not dispose of the case. Our victim doesn't actually have to be frightened for there to be an intent. What if the victim said to the 3 guys, "Get out of here. I'm not afraid of you. Leave me alone." And he showed them his own gun. He's not afraid of them. Could we still find a crime of attempted robbery? The answer is that we could still find the crime of attempted robbery. His not being frightened doesn't change their intent. And in fact, that's the whole point of specific intent crimes. It's we look at our defendant's intent. What did the defendant want to do? And even in that example, if our victim wasn't scared, our defendants would still have had a sufficient mens rea to rob the victim.